Hey everyone, and welcome to my third video on patent 6343263 for IEOR 190G at UC Berkeley. This video is going to be similar to my previous video, except last video you may remember that we were talking about some of the reasons why this patent or rather why some of the reasons Android and Windows Mobile and Nokia were violating this patent with their smartphones. And today we're going to be looking at some reasons why they might not be. So we'll be taking a look at the other side of the issue. Now, I found it difficult to find the actual reasons that are being used by the lawyers because the case files aren't easily available. But I'm going to be looking at some of the possible approaches I believe they may take. Last week I talked about a Huffington Post article where the individual writing the article talked about how he thought this patent could include faxes, wireless phones, and even internet-connected refrigerators. So this is a very broad patent, and just a review on it, give you the abstract for the first claim. It's a signal processing system for providing a plurality of real-time services to and from a number of independent client applications and devices. So essentially you can think of it as a modem that filters lots of different types of data. So we see that it's very likely that this is being used in the Android phones, but here's some approaches that might be used in the trial. First, it is an extremely broad patent, and the attorneys may use that to their advantage. There's several things they could do with that. The best strategy they may try to undertake is to try to find some prior art where something like this essentially existed before. And I don't imagine that would be all that difficult to do. Well, I mean, it probably is. I don't know. Compared to other patents, since this one is so broad, I think there's a lot more room to find something that could fit under the definition of the patent and invalidate it. So I'm sure there's people out there right now looking very hard to find something like that. Although it remains to be seen whether anything will actually come of it. Another approach could be the definition of real-time API, and this probably would have been their strongest approach until recently a very prominent and well-respected U.S. judge from the Northern District of Illinois essentially sided with Apple's interpretation of real-time API. But that doesn't mean that they can't still argue it, and they very likely will. So by real-time API, that's essentially the particular system, or it's often a coding language or a software format that they use to interact with, to essentially make the various processes of the patent work. And so this is key to the design, but if Android or HTC rather can find a way around this, then that would solve their issue. Lastly, an argument they could use is somewhere along the lines of patent abuse or unreasonable terms, similar to the defense that Barnes & Noble had in their lawsuit where they were trying to fend off Microsoft. And I really think that this, even though it's damaged, is a good strategy because they did win using the strategy against Apple in the ITC court before. So this has been essentially reopened in a district court, but the principle still applies, and they're very familiar with the case. So even though Apple seems to have an edge up on them right now, I still think there is a lot of potential for them to actually end up winning this. And once again, just the ramifications of this lawsuit, since it affects pretty much the entire Android system and all HTC's smartphones, along with Windows mobile phones and Nokia's smartphones. This is definitely a very important case because either they'll have to stop production or pay license fees to Apple. So this could be a very big victory for Apple, and it could be a nice save for HTC and other companies involved in the lawsuit. All right, well, that's it for now. I will see you next week.